Good afternoon. My name is Kimberly Hurtado. I'm an attorney. I practice construction law. I have been an associate member of the Metropolitan Builders Association for more than 20 years. And the focus of my practice has been in representing primarily contractors and specialty contractors. One of the things that we see frequently in my office are people who are trying to preserve construction liens and or foreclose on them to get paid. We are going to talk today about the process that's used to properly preserve a construction lien. Now, you have some handouts, some materials that go with this seminar. That the notes are there for you to refer to again at any time, along with the forms that the State Bar of Wisconsin created in 2006 when the lien laws changed. Now, how many of you have been to the Metropolitan Builders Association and gone to the lien law seminar before? A few folks? Okay, let me ask you a question. Do you remember how it is you're supposed to mail a notice of lien to an owner? Do you remember by what form you're supposed to send it? Registered mail, return receipt requested. That used to be the answer. And today I'm going to tell you about all the changes that have taken place. Some really exciting changes took place. About 5 years ago, as I started doing these lectures for the Metropolitan Builders Association, contractors would come up to me after the sessions and go, "Why are they making this so hard? We need to make it easier. We need to make it more cost effective." And the State Bar of Wisconsin took that to heart, and they created a committee. And that committee worked very hard for a number of years to make the changes that we're going to talk about today to the construction lien law. Now, for those of you who have not been to this lecture before, construction liens are unique. They're a very powerful remedy. The reason they're powerful is because there's a potential that the owner of property that gets improved by your work might have to pay for that improvement twice, 2 times, if something goes wrong and a trade contractor isn't properly paid. And because there's this potential for double exposure to the homeowner, and that affects the lender and sometimes the title company that might be involved on a residential project, the statutes were created to give this remedy to builders, but only if the notices that are required by statute are very strictly and carefully complied with. So today I'm going to teach you that timeline. Teach you so you feel comfortable knowing what notices go when and why. And not only talk about the process of lien law, but also the tactics. When do you want to send a notice to get greatest impact back? Because the whole point of these lien notices is to get you paid. Get you paid. Now, what happens if you don't get paid and you file each one of these notices properly, is it gives you a right to foreclose on that residence that you just constructed, sell it at a sheriff's sale, and use the proceeds to pay off your lien. That's a very powerful remedy. That remedy is so powerful that it requires a series of notices. Not just one notice to the owner, but in Wisconsin, for residential property, a series of 3 notices. 3 different notices you have to preserve. And it makes a difference in Wisconsin whether you are working directly for the property owner or you're working as a subcontractor, a supplier, somebody further down in the food chain. Now, what's supposed to happen on a typical project is that you get a payment, and if the owner or their lender is knowledgeable about lien law, they'll ask you for a waiver. How many of you in this room have seen a construction waiver before? Everybody. It's a very common document in Wisconsin. It's very often used. It's used so commonly that people will often give their lien waiver before they've even gotten payment. Now, I once did this lecture for the Fond du Lac Builders Association. I was up in Fond du Lac, And there's a guy in the back of the room. He said, you know, I've been doing electrical work for Joe for about 50 years. And every year around the football season, when the championship games get on, I go on down to Legal Blank and I get one of those pads of lien waivers, and I just sign the bottoms of them and I give them to Joe. You know, and then I never have to worry about those lien waivers. And I said, you don't have to worry about this class because you've given all your lien rights away. Those things seem like an innocuous little simple piece of paper, but they actually are very powerful. And if you use them strategically, you can use it to help you get paid. Now, we talked about this 3-notice system on projects that start after April 10, 2006. This is the one date I want you all to write down. April 10, 2006. If your project starts after that date, the new rules apply to you. If your project happened to start, you're building a really big residence and you're still in finishes right now, but you started before April 10th, 2006, the old rules apply. If you need information about the old rules, I want you to stop me during a break or after class, and I'll be happy to get them for you. But today, we're going to be talking about the new rules, the rules effective April 10, 2006 and after. Now, what's new about the lien law? What is it that the lien law is doing that it didn't do before? There has been a broadening of what you can put a lien on a residential property for. For the very first time, repair and remodeling are lienable. I used to go through this lien presentation, and about halfway through, we started talking about, I'd get a question about repair and remodeling, and I'd say, I'm very sorry, but remodeling isn't lienable. Because there's a long line of cases in Wisconsin that said repair doesn't add any new value. And people who did remodeling said, you got to be kidding me. If I put a new roof in, put a new furnace in a building, that's not adding value to that house, it's extending the life of the house. And we made that argument, the State Bar Committee made that argument to the state legislature and got these kinds of work added. But look what else you can have. Demolition, alteration, excavation, filling and grading, tilling, planting, clearing, landscaping, anything done for the benefit of improving real property. Now, that means that you're going to have some sorts of work that potentially are not lienable. And they're tied to a new definition of first visible commencement of construction. What the statute says is that a lien can attach as of the date of first visible commencement of construction of the work. So, for example, if you happen to be a high-end residential builder and you have designs that you use, you create the designs for the project, and then sometimes you don't always go forward with the house. Recognize that until that first shovel goes into the ground, until you have first visible commencement of construction, you don't have lien rights. So if you're going to do that design work as a residential contractor, you want to protect yourself a different way. You're going to get a payment up front for those designs, or get paid when you give the designs to the homeowner, for example, because you know that until construction starts, you don't have lien rights. Once construction starts, everybody who works on the project has lien rights. So your designer has lien rights. The guy who came out and did a survey has lien rights. The guy who comes out and digs a well has lien rights. The person who comes out and throws some stone so that the rest of the crew can get out to dig the foundation pit, those people all have lien rights the minute that digging for excavation of foundation starts. Now there's two different tests for visible commencement, because now remodeling or adding on to an existing structure is clearly lienable. If you have new construction, brand new, you got green site, it's when you start digging the foundation, footing, or base of the new construction. Okay? So your foundation excavation person, the day they start work, it's a very important date for you to log in your records. One of the things that happens, because this is all time-sensitive notices that we give, one of the things that often happens is somebody will come to me and say, oh, I need to file a lien. And I'll say, great, when did construction start? And they go, and I have to say, well, was it snowing? Now that gets you 6 months in Wisconsin. That's a hard thing to pick. So it's better, instead of having to guess about that you make a very specific record in your notes. If you're going to preserve lien rights on projects, on a residential project, put a record in your notes of the start date of excavation. When did you get those digging for footings, if we're going slab on grade? When did you get the digging for the foundation, if you're digging a basement? That date is critical to you. Now, sometimes you're sitting there right now going, shoot, I don't remember for the project that I want to put a lien on now because I'm just learning this lien law right now for the first time. Where you're really stuck, go back to when you pulled the building permit and use that to try and help you jog your memory, and or go back to your subcontractor invoices. See if they can help you with the documents that you have, okay? But that first, the visible commencement for new construction is that foundation. The test for adding on to an existing building, it's a little softer. It says substantial excavation or the beginning of substantial preparation of the existing structure to receive the added new construction, whichever is earlier. Now, I got to tell you, lawyers think that they're being very clear when they say something like this. And they really are trying. But what constitutes substantial? What is the beginning of substantial excavation or substantial preparation? That can be sometimes kind of hard. What happens, for example, as often happens in Wisconsin, you get out there and you go to dig the hole and you have 3 weeks of rain after the first day and your walls cave in. What date do you want to use for substantial completion? Generally speaking, from the contractor's perspective, you want to use the earliest date you possibly can. But you want to fairly represent when the start of construction commenced. So you want to look at when you were able to continuously move forward from that point forward, and that's the date you want to pick for renovation of an existing structure. So there's all kinds of preparatory work that you might do out at an existing house to get ready. You might go out and do some field measurements. You might go out, draw some designs, meet with the owner, bring some samples. None of that's going to count. You're going to look at, if you're adding square footage, you're going to look again at digging footings and foundations. Or if you're tearing out an existing structure, the day you really substantially begin the work itself and not that is improving the real property. That's the test. That's what this whole set of laws revolves around. When do you add value with your work to the real property? That's the question you ask yourself. And for renovation construction, that's what substantial commencement is. Yes, sir?
The finer point, I mean, now a lot of municipalities make us put our silt fence in right away before we can start excavation.
Oh, should you count the silt fence?
When you're digging a trench to put the silt fence in.
Yeah, you dig a trench to put the silt fence in. I could see an argument going either way for the silt fence, because you're digging a trench and you can't proceed without the silt fence being there. Those are the arguments in its favor. The arguments against it is, what value did you add to the property by putting that silt fence in there? What real permanent improvement of the property did you make? Probably not with the silt fence. If you're doing new construction, I wouldn't rest on that. I would look at a new construction, I would definitely look at when you're digging the foundation. The first day you dig the foundation, and preferably continuously dig the foundation. Okay? But that's a good point, that there's all these preparatory activities that happen on a construction site that you think, well, I'm out there working, I got a building permit, But for the purposes of the lien law, it's not enough. You got to go a little bit further. Okay, questions about first visible commencement? Let's talk about who a prime contractor is. Now, I'll bet you dollars to donuts if I look at your contract right now for doing some construction, it does not say you're a prime contractor. Anybody say that in their contract? Not a darn one. That's exactly what I thought I would find. Okay, that's because the lien law has its own special definitions, okay? And what it does is it creates this definition of prime contractor and then everybody else who is not prime contractor. So what does that mean for you? How do you know which one you are? The prime contractor is anybody who has a contract directly with the owner of the real property. Do you work for the owner of the real property or that owner's authorized agent? Now, how are you going to know if you're working for the authorized agent? Unless you ask, do you own this property? And sometimes the answer will surprise you. You know, you get a young couple out there and mom and dad own the property that you're building for. And they really don't have the say and authority to commence construction. You protect your interests as a contractor by asking questions like that at the front end before they sign your contract. Now, you can get into situations, and I've asked around the room before the class, you can get into situations where you sometimes wear the hat of prime contractor, and sometimes you're not a prime contractor. So for example, you typically work as a subcontractor to a general contractor that does residential construction. And you do, let's do millwork. Okay, so we're out doing millwork, and we're going to do, what should we do? Kitchen cabinets. Let's do kitchen cabinets today. And you very often the general contractor will say, I'm going to send Herman Munster over to you to pick out kitchen cabinets. Really, Herman and his wife Lily, very nice people. And Herman and Lily show up at your shop, and they go, ooh, ah, and they pick out the cabinets, and you help them out. You draw a little picture, and then you coordinate with the general contractor. Very clearly in that set of facts, you aren't the prime contractor. You are not the prime contractor because you don't have any contract. Now, what's a contract in Wisconsin? There's 3 parts to a contract in Wisconsin. This isn't in the lien law, so this is something you might want to write down. Offer plus acceptance plus consideration equals contract. Offer plus acceptance plus consideration equals contract. What do those words mean? Why do lawyers talk that way? Offer is, I offer to do something for you. I promise I will do something. I give you a bid. A subcontractor can give you a bid. That's an offer. Acceptance. I accept your offer. You're going to build me a house for $5,000. It's going to be a doll house. It's going to be a little kid's toy house, but it'll be a beautiful one, right? Offer, acceptance, and consideration. Consideration is what gets exchanged that has value. It doesn't have to be money. If you will come in and do this extra work for me, subcontractor, I will give you the Smith project next month when it gets going. And you'll be my contractor. It doesn't have to be money. It can be, I'll give you this extra and you'll agree to waive a claim against me for falling into the foundation hole on the site. I mean, it can be all sorts of things besides money itself. Offer plus acceptance plus consideration equals contract. Note what isn't required to make a contract in Wisconsin. It doesn't have to be in writing. It doesn't have to be signed by the parties to be bound. An oral contract. I can make a contract with you right now. I offer to teach you about lien law. You accept by, I'll say, if you sit here, you're accepting. And the consideration is you paid a fee for coming here today. We have a contract. Even though there's nothing in writing, nothing binding us. You just all agreed to be nice and attentive for my presentation. Not exactly. There's actually some rules that go beyond that. Question?
Okay. I have what we perceive as a problem with our company because we do not get the offers for the agreement signed by the client in most cases.
Okay, so you make a proposal to the client,
Right.
but then you don't make the owner sign it. You're killing your lawyer friend here. Okay?
The salesperson has a hard time collecting these.
Okay.
Or gathering these. And so for me, the real mitigating thing on this is that our first notice of lien claim is on that contract.
Okay.
Okay, and we really haven't been bitten by it yet, but.
Okay, so what he's saying
So you're
is,
saying, what I heard you say though was, even though we presented.
you have a contract. If they present a proposal to build a house, and the owner looks at it and says, Heritage, do this work for me. That's your company. Do this work for me. And you go out and do it, and you invoice them for that price, you have a binding contract because you had an offer, it was accepted, and the consideration, the money that was going to be paid in exchange for sanding some wood floors, let's say, is traded. Offer, acceptance, consideration equals contract. But here's why you don't want to not get something in writing. Okay? Let's say you have an oral contract just on those exact same terms. And that's contractor A. Contractor B over here did exactly the same thing, but he said, owner, sign my proposal right here, please. Okay? Contractor A and contractor B walk into small claims court wanting to collect $2,000. Okay? Contractor A walks in and the homeowner goes, oh, I didn't say I would accept it for $2,000. I thought it was $1,300. Or no, I didn't know it was really going to be 2 coats of finish. I thought it was 3, and I should get a 3rd coat. And owner says, I don't even know these guys. They came into the house and they wrecked my floor. Okay? Contractor B walks in and says, Your Honor, here's a copy of my written contract that says I was going to do it for $2,000. Here's a copy of my picture showing the beautiful work that we did, and I'd like to get paid. Contractor B gets a judgment like that, called summary judgment. We'll talk a little bit more about that project a little bit later, a process a little bit later. Contractor A goes into discovery, and 12 to 18 months later, maybe gets a judgment for $2,000. That's the power of written documentation. And it's easy to protect yourself, especially, I mean, think about this. Residential construction, for very many of your clients, it's the most expensive thing that they'll ever contract for. It really, truly is. It's the most important thing that you'll ever do for them, is to build their home, build their dream house. You only ever build a dream house. That's my experience. I've done 20 years of construction disputes, and invariably on residential projects, within the first few minutes of meeting the owner, they tell me, it's my dream house and it was ruined. Okay? So you have to start with that premise that you're building a dream house for somebody, and if you have the ability, while the bloom is on the rose, if you will, to get their signature on a document that defines what is going to be built. So that you have an offer that's clear, an acceptance that's clear because it's in writing, and the consideration, what's going to be built and how much you're going to pay for it, is clear in writing. You have a much more powerful ability to collect in a contract case than if all of that happened orally. Now, why am I going on and on about offer, acceptance, consideration equals contract? Because, let's go back to our example now. Are you a prime contractor, or are you in that vast group of other sub-suppliers, designers, others, surveyors, interior designers, and miscellaneous trades and manufacturers who don't have a direct contract with the owner? It could be possible. Let's go back to our kitchen cabinet example. That owner is over at the kitchen cabinet place, and they're picking out the cabinets of their dream for their dream house. And the supplier of those cabinets writes everything all down, says we're going to give you so many of this cabinet style, so many of this size of this cabinet, this is the color of the finish, all the particular specifications. It says, owner, sign here. This is what you want, and we'll get started on the fabrication. Do you not have an offer with acceptance? And if you put money on what that thing is going to be, consideration? So that you have that piece of paper, even though it's an order or a purchase order or a bid, is acting like a contract? If you do, it could be you wear two hats. You're both a prime contractor, because the owner signed a contract with you, and a sub. So if you're a general contractor in the room and you do residential construction, if you don't want that process to happen on your projects, you want everything to flow through you, you have to make sure what your subs are going to do to document the change, to document the selection, and make sure that those selection documents get to you. If they're going to write up specifications and have the owner sign so everybody knows what's going to be built, fine, leave the dollars off and get the dollars to the general contractor. That's how you keep it from being a contract within a contract, if you will, and avoid that confusion. Now, you also can sometimes get confusion because the contractor's going to do the kitchen, and they get in there and they go, wow, you do crown molding too. And it's not in the general scope of work. General's not going to do it. You call up the general and say, General, is it okay if I sell them some crown molding too? They really want it, and they're going to put it up themselves. General goes, I don't care. And why are you as a subcontractor doing that? Because oftentimes the general has a right of marking up your work and coordinating it if they so choose. But let's say the general doesn't mind, and now you have a contract for crown molding, and you have a purchase order for cabinets. You're wearing both hats again. You could be both a prime contractor and what I'm going to call from now on in this lecture a subcontractor. Anybody else in the food chain that doesn't have a contract with the owner. If you find yourself in that hybrid situation, the better practice is to send out both kinds of notices. One for the things that you sell directly to the owner, and another as a subcontractor to make doubly sure that you have properly sent out notices. I lost my... Oh, I'm so sorry. I got a pointer. I'm sorry. Okay, I'll try to behave. Okay, why am I not? Okay. In the definition of prime contractor, is there a way we can maybe make this a little darker? Oh, okay, it'll get darker. Okay, here we go. The new change to the definition of prime contractor is that for the first time, it expressly includes architects, engineers, construction managers, which more and more residential big-end houses are going to construction managed form of delivery, surveyors, and other service providers employed by the owner. So there's a very broad group of people now. If you have a contract with the owner, you are the prime contractor. The next huge change, yes, sir.
Examples of other service providers?
Okay, I'm going to come onto your site and I'm going to do geological testing, or it's an existing building and I'm going to come in and I'm going to examine to see if you've got asbestos or PCBs or lead that needs to be abated before you can do your renovation. I'm going to come in and I'm going to make square footage analysis and do an FF&E build out and do interior design for you. I mean, there's a wide range of things that are not necessarily true general contractor, especially as you get more into commercial construction. These rules are created for both residential and commercial, but so some of the unique other service providers would fall into that category.
How about an appraisal?
Appraisals. I think that the law is not clear about appraisals, but I would say not. And here's why. It doesn't improve the real property. There's nothing tangible you put into that property or took away from that property that improved its value.
But a designer doesn't necessarily need it, it's just on a piece of paper.
If that design, there's two sets of cases about a designer and about temporary forms that are used to inform the residential construction, Lien Law. A designer whose plans actually get executed in the field adds value because without those plans you couldn't construct and you couldn't lawfully get a permit. And so for that reason a designer's plans are lienable. But until construction starts, there's no lien rights for the designer. For temporary forms, even though they get stripped away, like you're going to do some concrete forms or something, you're going to do some fancy exterior or something like that. The temporary forms, but for those temporary forms, you could not build the finished improvement. And so again, they'll say a lien is created in that instance. Question?
Well, with the appraiser, he's potentially creating the ability for the mortgage to be able to pay for it.
That, you know, you can make that argument, but I don't think that's going to stick because a mortgage itself does not improve the real property. Yeah.
We actually ran into this recently, and there's a very old law that came into play, and it makes no sense, but even if the owner pays you directly to do an appraisal or hires an appraiser, but it's for the purpose of a mortgage with a bank,
Uh-huh.
the appraiser's working for the bank, doesn't matter who paid him, and actually the homeowner doesn't even have a right to get a copy of the appraisal, even if they pay for it because it's tied to that mortgage, so you didn't really work for the owner, you worked for the bank. Unfortunately, banks don't pay appraisers anymore, the longer they work for most of the time.
Yeah, so even though on a closing statement an owner pays an appraisal fee, they are not the owner of that document. And yet another reason why you would not treat that as an improvement to real property. Another question back here.
Yeah, if you're using the example of the millwork supplier or the kitchen, if you're working for a builder, obviously you're the subcontractor, but then if you have a homeowner come in that is acting as the general or generaling their own home, and you contract direct,
Then you're a prime. Then you're a prime. And why is that? Because your contract, which I hope is now going to be in writing from now on, signed by the party to be bound, is with the owner. An owner can general their own house and have multiple prime contractors building. Perfectly legal in Wisconsin. An owner can hire a construction manager who hires multiple prime contractors. And again, your contract in that instance as a prime is directly with the owner. Yes, sir.
Is construction manager and general contractor interchangeable, or is there?
A construction manager is treated for insurance purposes differently than a general contractor in Wisconsin. Many of their duties are similar, but the one large distinguishing feature between the two of them is that with a construction manager, they're there to administer, supervise, and direct prime contractors, but they don't have the ultimate contract with those prime contractors. The primes contract with the owner, and the construction manager merely assists in the supervision and administration of the project. A general contractor is like buying a black box. I don't care if pixies come out and build the house at night. As long as at the time it's done, my house is completed per plan and spec, I will pay you a fee. And I don't care how many people worked on it in the interim. With the construction manager, there's an open ability of the owner to see each prime contractor and know what they're charging. And typically a construction manager gets a flat fee on top of those charges. They get a percentage of the total cost of construction for administering and supervising. It's a slightly less complete obligation. And liability, if the prime screws up, is typically less for a construction manager than for a general contractor. General contractor is kind of like one-stop shopping. I'm buying a black box and it's going to be a house that looks just like the plans and specs when I'm done.
If you do a project and you reveal all of the contractor's costs, it's an open bid process, you automatically become a project manager?
A construction manager? Okay, so the question is, if you do a contract, a residential contract with an owner, and you do it on basically a time and materials basis, you're going to show all of the costs and stick a fee on top of that. You still could be a general contractor if you're being responsible for each of those subcontractors' work and you contract with the subs to do the work. If you are managing multiple primes who have contracts with the owner, then you would be a construction manager. So it's not so much are you doing it cost plus fee that drives it, but who is responsible for that contractor's work, either the prime contractor or the subcontractor's work at the end of the day? Is it you or is it the owner? If the owner has to go back and deal with the complaints, then it's a prime contractor. Under the example you gave, where you are hiring all the subs, but you're showing the cost and saying, I'm going to do it at cost plus fee. I'm not going to do it for a lump sum. I'm doing cost plus fee. You're still the general contractor under that set of facts. Okay? It's kind of a tricky area, and sometimes it's a very blurred area. But what you'll find is that insurance for construction managers is different than for general contractors. And if that's an issue that you're facing, let me know, just write me a little note, and I can talk to you about it more during the break. We won't talk more today about that particular topic. Okay, other question about lien? Yeah.
Is there a drawback in the example you gave of the owner going to the cabinet shop and actually signing something to the general contractor if they end up having both as prime?
So, okay, so now you're a general contractor, and you've been sending your homeowners over to the cabinet shop, and they've been signing off every time, and it shows the price. And you're going, shoot, I just made this messy thing for that sub as to whether they're a prime or a subcontractor. And I don't know which set of notices they're going to use. It doesn't hurt you, but if you get to a place tactically where you want to use your sub's lien notices along with yours to spur the owner into taking action to pay you, you're going to have to be very careful to give instructions to that sub to send their notices both ways, which would mean that if you are that millwork cabinet contractor, on the purchase order form would be your first notice if you wanted to be treated as a prime contractor. If you're a general contractor, in your construction contract would be your first notice. If you're a subcontractor, you have a little window of time, and we're going to talk about that sequencing and the difference between a prime's first notice and a sub's first notice. But let's talk about something that is really new, and I think the most exciting good thing that came out of the law changes in 2006. And that is, it used to be you could hand deliver these 3 notices we're going to talk about today, or you could mail them. Registered mail, return receipt requested. And I used to make people say that in my lecture over and over again so they'd send it the right way and not send it certified and not send it by carrier pigeon or whatever other way. The law has changed. Now, anytime registered, certified, service a process, you can have a process server come. You can have any other delivery method where you get written confirmation of delivery. So you can send it by express mail service, U.S. Post, anything that gets you something in writing that shows it's been delivered. Note that it doesn't have to be signed by the owner. So you could have a process server come and give you an affidavit that says, yes, I served Herman Munster. You know, because sometimes what was happening, bless you, what was happening was savvy owners who understood about lien rights were rejecting registered letters and wouldn't sign for them. It created all kinds of havoc for the poor contractors who were trying very hard to get paid. And so this rule got broadened. It's more than just registered mail and personal delivery right now. But you do have to have written confirmation. And when you get that written confirmation, you're going to keep a copy of the notice, each of the 3 notices that we're talking about today. I want you to staple that written confirmation right to the notice so you never lose it. Okay? Look at your timeline. Does everybody have a timeline? This timeline is something that I created for our firm's clients because I wanted to make sure that they weren't missing dates for a particular project. And we've made this as a separate page. Feel free to make photocopies and throw one of these in every one of your project files if you want. And what it is, it takes you through the various deadlines, whether you're a prime contractor or you fill that subcontractor any other role besides a prime contractor. And it's a reference tool to remind you about the deadlines that are going to be used. If you have a particular project right now that you're thinking about filing a lien, why don't you go ahead and use this form and kind of mark it up and see if you can fill in the blanks as we talk today about the 3-step notice process that we're going to use. Now it starts with prime contractor notice of lien rights. If you have your lien forms, I want you to turn to this form right now. Prime contractor notice of lien rights. It's on the back of the timeline. Anybody need help finding it? Good? You're in good shape? Everybody help everybody else? Yeah? Excellent. Thank you so much. Okay. What the statutes say about this notice is that it's the first notice given on a construction project. And there are 4 exceptions to when it must be given if you want to preserve lien rights. It must be in your written contract if you have a written contract. And if you don't have a written contract because they didn't sign your proposal, within 10 days after the first furnishing of labor and materials on your job, you have to give 2 copies of this first notice to the owner if you want to preserve your lien rights on it, or an oral contract. But if you have a written contract signed by the owner, this notice should be in the contract. Now look at what it says. Basically what it says is, I'm your prime contractor. I and the people who work on my project have lien rights. I'm giving you 2 copies of this notice because I want you to give one to your lender to let him know that we have lien rights on this property. And if there's ever any problems with liens, I'll work with you to make sure they get resolved. If you follow the practice of the most prudent residential construction contractors and go paragraph by paragraph through your written contract with the owner before they sign it, so that it's very clear what it is you're building and when payments are due and how they're going to be administered and how changes work on your project. When you get to this paragraph, you say, you should expect that my subcontractors will be sending you notices to let you know they're going to be working on this project. If you get some, just do me a favor and shoot me a copy of them so I know that you've got these lien notices. And what you're really doing is educating the owner that a first subcontractor notice is not a lien on their property. How many times have you had a first notice from a sub go out and the contractor gets a call from the owner, there's a lien on my property, I just paid you, what's the matter, you should have been paying my sub. How many, have you ever had that happen? Sure, all the time. And that's partly because as the general contractor, nobody bothered to explain to the owner how that works. Now, lenders and title companies, I think, are getting better in the industry about explaining that process. But even when they do sit down and explain it in detail, sometimes they're dealing with somebody who's not the brightest bulb on the Christmas tree, and they don't understand that process. If somebody's really asking you a lot of questions about this lien paragraph, you have to say, what's your concern? This is only for people who don't make payments when they're due. That's not going to happen on your project, is it? And now you smile right now, but what are you doing? You're planting the seeds at the beginning of your project in your contract negotiations, that if I do my work on time and of proper quality, I expect to be paid, and I expect you to pay me on time. And this only will come up, these liens will only come up if you don't pay me. I would only do something like liening your house if I don't get paid. So you can use this as a tool right from the very beginning, as an alert, and it gives you some feedback, something about, you're getting to know your owner. The whole time you're going through the specifications, you're going through those plans. It's kind of it's like a dance, isn't it? It's kind of getting to know this person, kind of trying to understand the legal sophistication. Do they really understand what liens are, or are they totally hopelessly lost? Because it's the hopelessly lost person who's going to call you at 7 p.m. on a Friday night going, I got a lien notice, oh my God, the sky is falling. Question?
The people that spoke before you said never bring a negative aspect into your client negotiations.
Well, it's not negative to say that my subcontractors will give you notice so that you know that they're working on the job, and that I will be responsible for collecting lien waivers from them and getting them to your title company. That's part of the process and all part of the price you pay me as a responsible general contractor. You can put a spin on it that's very positive, and you should be making a positive pitch there. But, it gives you the ability to test, but this is only for people that don't pay on time. That's not going to be a problem here, is it? Very light, very joking, but still gets the point across that you have to get paid at the end of the day. Now, the statutes have a bunch of fussy requirements about this if you're going to put it in typewritten contracts, because it's possible in this day and age to get very tiny type. How many of you use MBA standard forms for residential construction? That's totally cool, because you automatically have the first notice in there, and it's the right type, point, face. 8-point type, bold. Now, if you don't happen to have, that's really tiny, by the way. If you're writing the rest of your contract in 8-point, I hope you have magnifying glasses for your owner to work with, because that's really teeny tiny. But if you do, it's got to be bold. Make it in caps. If this is the one paragraph in your residential contract that's going to really stick out, because if ever there's a question, did you give the right notice, it sticks out like a sore thumb for a judge or jury to see, yes, absolutely I did. It's right here, paragraph 32, bold, 24-point type, right there. Or you can take this form that we're looking at today, the State Bar form, fill out 2 copies, and just staple it to your contract if you're not using the MBA form. Absolutely permitted. Absolutely okay. You can put that same form right on your letterhead. And you can add a paragraph at the front and the back to it, and it's still legal. Because the statutes say in substantially the form or language of the statute. Now, what the statute says is exactly what's on that form for the State Bar. But you could, for example, instead of saying contractor, you could say your company name. You could customize it to your company name. Fill in your company address so you don't have to fill these forms over and over and over again, and make it customized and easy for you to put in your lien rights. Now, I bet there are people in the room today who don't use the MBA form who are going, shoot, I didn't give a notice like that to my homeowner when I signed my contract. Am I out of luck? Because I heard Kim saying you got to follow these notices exactly or you don't have lien rights. Well, for prime contractors, and prime contractor is anybody who has a contract directly with who? The owner. For prime contractors, there's an exception. And that exception is if you pay all your subs and material suppliers in full so that their lien rights are extinguished, if you fail to give this notice at the front end when you're contracting, you can still give it late and have lien rights. Now that's good, but that's also horrifying. That could be a lot of money at stake to get your lien rights back.
How late is late? Does that go on for the whole term of the construction contract? Do they do that right up until the final date?
The latest that I am aware that you could give this notice is the latest time that you have to give notice of intention to file claim for lien, which is approximately 5 months after your last work on the project, whether because the work is done or you walk off the job. But that would be the last time you could possibly give this and still maintain lien rights. Okay, questions about prime contractor notice number 1? No? Excellent. Yes, sir.
What happens if a prime contractor signs, if you're a sub and you're working for prime subs signs a contract, but he later notifies you that the owner will be paying you directly. So you're contracted with them, yet they
Wow.
after the fact, it's you're being paid by the
Okay. At the time, so the question is, you start as a sub. You don't have a contract directly with the owner. But for reasons that are unclear, mainly because you want to give yourself a bad headache, the owner says to the prime contractor, I want to start paying your subs directly. And the prime says, okay. So now you are being paid by the owner directly, even though you were hired by somebody else. The statutes would probably treat you as a prime contractor under those circumstances, and the general that hired you as the agent, authorized agent of the owner, which is one of the 4 exceptions to when you have to give a lien notice to the owner. So you could argue for that exception, but the better practice would be at that point to ask the owner to sign something that is a contract with you for those direct payments, if you wanted to preserve your lien rights as a prime contractor. You still could, because you were hired initially by the prime, send out the subcontractor lien notices and still have properly preserved lien rights. But if you wanted prime lien rights for some reason, that's the way I would preserve them. Question?
Along that same vein, when you're talking about getting paid directly from the owner, how about when with the title company, when all of a sudden the builder's having difficulties, the lender says to us, we're going to instruct you that now you must pay all subs direct. The funds aren't truly coming from the owner's pocket, however they are owner loan dollars. Does that really still apply?
Okay, so the question is, sometimes a general contractor will run into trouble, or an owner will force a prime contractor to allow direct payments from a title company to the subs. In most instances, that occurs under, if the title company has any brains in their head, they're requiring a written document to protect themselves in that disbursement. And that written document is the general contractor approving that disbursement. So you are still, the general is still controlling the flow of funds, and you would still be a subcontractor under those circumstances. It doesn't convert you to a prime. If the checks start coming from the private personal paycheck of the owner, now I start worrying some more. If you've got like the just general account of Herman and Lily Munster, it's not, they're foolishly not running through a title company in this day and age to disperse their payments.
Point to make there, because any of these guys who are subs, they may not understand that division there. If it's panic button if now they're getting funded directly from a title company and saying, oh, now I'm a prime. See what I'm saying?
Right, that they might think just because the title company is paying them directly that they are somehow converted into a prime. I don't think that that is the case. It would require, but if you have a doubt, the best thing as a subcontractor to do, or if you're the prime contractor and you're agreeing to this arrangement of disbursement to your subs, is to make that an agreement in writing that says the general agrees for this payment in lieu of paying the general directly and the general furnishing the waivers of the subs. The general allows the payment to be made to the subs directly in the following amounts. You give them a disbursement control affidavit that splits those all out in exchange for a sufficient waiver. And then the title company collects the waiver in exchange for paying the sub. I don't think that that changes the hat and turns you into a prime contractor if you started out as a subcontractor in that arrangement. Other questions about if you're a prime contractor or a sub and giving the first notice? Now, if you are a lender, I don't think we have any lenders in the group today, but if your lender wanted to, until this first notice is given, the lender doesn't have to fund the project. More and more, especially with the credit crunch in the United States in residential credit, you're seeing lenders become very fussy about proper lien notices being given. Why? Because they want to make sure they have clear title to property. It happens all the time. An owner will say, come on out, dig the foundation for me. I'm still working on getting a loan. That's a very dangerous thing for the lender to loan on, because your work, first visible commencement of construction, happens before the loan gets recorded of record. So what does that mean for the lender? Your lien rights actually could arise ahead of that lender's under certain circumstances. That's the last thing the lender wants. Lender wants only one thing, and that is nice payments of principal and interest once a month. They never want you to foreclose on this piece of property. And if you do, they definitely don't want to stand behind you in getting paid if you do foreclose and sell it at a share of sale. So a lender, you may see lenders more and more asking to see your first lien notice. Now, if it's in your contract, you just say, see paragraph 32. Or I attach 2 copies on the back. And why do you give them 2? Because one's supposed to go to the lender. One's supposed to go to the lender. Subcontractor identification notice. This is still notice number 1, but this is everybody else except the prime. Everybody have this document in front of you? Now this document, again, 2 copies. 2 copies go to the owner. Now if you're a subcontractor, how do you know who the owner of the property is? Usually the general will tell you what the owner's name and address is. But if you didn't know, here's some other places you can go to check. You can check with the Register of Deeds, but that's a little cumbersome to check and track title. I like going to the tax assessor's office. And very often in this day and age, the tax assessors of most municipalities have their records online. You can get on your computer, surf the World Wide Web, and boom, find out exactly who owns a piece of property. As a prime or as a subcontractor, that's a very interesting exercise to undertake, because you may think you know who owns property, but it might not actually be titled in the name of the person you're working for. That happens from time to time. And your notice number 1 for subcontractors, has to go to the party that owns the property at the time you send the notice. Yes, sir?
What if the property is owned by a trust?
Then you send it to the trust. And what you'll have, the tax assessor, the tax people always have the most current information I've found. I don't know why that is. It just happens to be. The tax assessor will have an address for that trust. At very worst, there should be a recorded trust instrument with the Register of Deeds and that will typically have, or a mortgage deeding it to the trust, and it'll have a return address on there. But if you ever have a doubt, ask. Ask, what address is the proper notice for the trust to be given to? Just ask them right up front. Other questions about how you access and find the owner's name? No? Now, if you are a subcontractor, now if you're a prime, why do you care if the sub does their notices properly? Because if they properly preserve lien rights along with you, and the owner decides to jerk you around, you can call up your subs and say, throw out a notice of intent. My owner's jerking my chain here. I want to put some pressure on him to settle. And now they can help you, work in concert with you, because you have them working together with you as a team. And so from time to time, you as a prime contractor will teach your subs how to use lien forms. So it's important to know the second step for notice number 1, identification notice. For subcontractors, you are a subcontractor. You don't have to give this notice if you're a laborer. If you contract directly with the owner, that's that exception we talked about where you're wearing different hats. But I wouldn't want to rely on that. Better to give the notice and protect yourself. When you are furnishing more than a 4-family. Now, some of you do multifamily housing, but the test is 4-family or higher. You don't have to give this first notice in residential construction. If you're doing 3, 2, 1 units, you still have to give this notice. Or you're working for a prime contractor that personally owns the property. How many of you worked on spec houses before? Almost everybody. If the general owns the land, your first notice is not necessary. Now what happens, what you have to watch as a subcontractor, is that on the day you start your work, it might be a spec house. But as work progresses, it might be purchased by an owner. What the statutes require for these notices is that on the day you send it, you look at who the owner is, and then you give the appropriate notice. Yes, ma'am?
So if someone's generaling their own project, as a homeowner, technically they're the owner and the prime contractors, therefore, as a subcontractor, I don't need to send this to them.
That's exactly right. Because you work for the owner. And what the owner really has is multiple primes, even if they call you a subcontractor.
So would I still need to issue them the prime?
I would still want to issue them the prime notice in your written contract to protect your lien rights in that situation, where the owner generals their own work and hires multiple primes to work on the various renovations or whatever they're doing. Okay? Those are the exceptions to when you as a subcontractor have to give notice number 1, identification notice.
Could you go over the
Go ahead.
4-family?
Okay, if you are building more than a 4-family or work that is substantially non-residential in character, is what the statute says, i.e. commercial construction, notice number 1 is no longer necessary. If you happen to build out strip malls occasionally, in addition to residential housing, on commercial construction, notice number 1 is no longer needed by your subs. That's a new change as of 2006. But if you're doing residential construction and a sub gives this notice, they have lien rights. If they fail to give this lien notice, they have no lien rights. And what the statute says is 2 copies within 60 days of their furnishing of first labor or materials. So if you come on and you're the excavator, you're going to be given that notice way at the beginning of the project. If you're the interior designer, you're probably not going to be given that notice until the end of the project. And so through the whole course of the project, there'll be a flurry of these little notices coming out to the owner. One of the things you can do as a general contractor when you hire a sub is say, if you're going to send out an ID notice to my clients, I would like a courtesy copy. Just send me so that when the owner calls me at 7:30 on Friday night, going, oh my God, there's a lien on my property, I'll have a copy already and go, no, no, Mrs. Munster, it's only an identification notice, and here's how those work. So that's something you can do. Yes, ma'am.
If you're a subcontractor, say you're providing windows on the roof,
Okay?
and the timeframe's obviously gonna go by, you get to the finish, you're providing cabinets and other millwork. Does that one notice you provided
Cover
follow
both.
through, or you
Okay.
have to then again send another ID notice?
Okay, a number of subcontractors do rough work, and then they come back and they do finish. What the statutes say, what they'll look for is, do you have a single contract for all of that scope of work? If you have a contract that's both for the windows and for the kitchen cabinets, let's say, as a millwork company, and it's a single contract with the prime contractor, within 60 days of first furnishing the windows for the rough, will protect the whole contract. If you're hired to do the windows, you furnish them, and they go, oh, by the way, can you also do the cabinets? And that is on a separate contract. I would say the better practice to protect you is do a second notice, just for the cabinets. Right, just as the sub. If you have two separate contracts as the sub, I think better practice is to protect you with two different notices, because you're providing two different scopes of things. Your first notice says, it's a written notice served to the last known address of the owner, which is the tax assessment rolls typically. It has to substantially follow the language of the statute. Now, what's in your packet follows the statute language, but because you have to only substantially follow it, there's all kinds of things this notice can do instead. It can be a very nice letter on very nice letterhead that says, hi, I'm your trim work contractor. We're so happy to be working with XYZ Construction Company. We just love working with them. They're the best. They rock. And, oh, by the way, the lien law requires that we give you 2 copies of this notice. Give one to your lender. If you have any questions, let us know. We're so happy you're going to be working. If you have any problems with our work, don't hesitate to let XYZ know so we can get the job done right for you. We're so happy to be working for you. Amen. Very truly yours. Perfectly legal in Wisconsin. Take all the sting out of it. Just include 2 copies. Copy your prime contractor so that the general contractor knows what's going on. Okay? You have to include a street address or other clear description. Some people use a legal description, some people use a street address. That can get kind of hard when you're doing subdivisions that haven't been fully platted. There's one very interesting case. There's a case in Wisconsin. It happens to be a commercial case, but it's kind of a fun story. These contractors were doing a Walgreens, and it was out on I-94 and a cross street, and their description was I-94 and 127th Street or something like that, and the court said, that's close enough, because it tells me where this was and distinguishes it from any place else. If you are working in a subdivision that isn't quite finished being platted, that sort of thing, and you want your subcontractors to properly preserve their lien rights, give them something. Give them a legal description. Give them a street address, something that identifies this particular unique parcel. And the other thing you can do, title companies, I think, can be a great ally in the process of preserving construction liens. Very many title companies in Wisconsin will, for a fairly nominal fee, under $100, will run what's called a letter report. They'll tell you the name of the owner, the address of the owner, a legal description for the property, and any other encumbrances of record. That means any mortgages, any tax liens, any judgments against that property. That is really critical and important information if you think you really might have to preserve a lien claim and start foreclosure at some point, to get that kind of information. The street address or the legal description can come from a title company. There are also services that will preserve your lien claims for you. I have had a number of claims for and against those kinds of companies. They aren't always so diligent. Sometimes they're national companies, and they don't watch the rule changes as closely as other people do. But there are services that can do these, but it's better that you know the rules yourself, so you keep an eyeball and make sure they do the right number of copies, that they send it to the right address, that you're giving them accurate information about when you started the work and so on. So that you're watching what they do and make sure that they properly preserve it. Because it's time sensitive, sometimes you only get one chance to do this. And otherwise you have no lien rights. They're gone. If you don't convey within the first 60 days of starting work as a subcontractor, the best that you can have is late notice. So now let's go back to our millwork example, where they furnish the windows in rough, and then they come back in finish, and they provide kitchen cabinets. Let's say at the rough phase, everything's still in a honeymoon phase, everything's going good. They didn't file any lien notices because they got out there, put in the windows. 2 weeks later, they had a check. They didn't need lien rights. But now, they're putting in the cabinets. And they're hearing rumblings out on the job site. There's a bunch of change orders. And they're feeling a little more worried, a little more insecure. You're past your 60-day window of first starting on that project. So your lien rights will never go back and attach to those windows. You don't care because you're paid for them. But you could put in a lien notice right now before you deliver the cabinets. And everything after that late notice is protected. But only after the notice goes in late. You follow that? So let's try an example, okay? That's kind of a little bit tricky. Let's say I'm going to do rough and finish plumbing. No, let's do electrical, because I like chandeliers. Okay? Guy comes in, he wires out all the electrical, pulls the power down, gets a box started in the house, and goes away for 18 months, because it's such a big, complicated house, nothing else is going on. Got paid for doing that rough work, and now is coming back to put in a $12,000 chandelier. And they get out to the job site, and there's a bunch of subs going, when am I going to get paid? And the electrical guy goes, oops, what's going on here? Let's say he takes that chandelier and he installs it in the house, and the next day he gives a 60-day notice. So he's given it late. Does he have any lien rights on that chandelier? No way, no way. Why not? Because the notice came after the work was done. Better to hold up for a day, give the notice, and then install the chandelier, huh? Yeah.
Let's say he's doing the finish electric, the big house is taking a week. First day, here's this stuff, starts working, sends a notice out, gets there halfway through the finish. Is it all or nothing, or prorated, or?
It is everything, all the work that happened after the date the notice got given, and the burden of proof will be on you, subcontractor, to tell what things you did on what days. So if you've got that problem, both you and the general want to take some pretty good notes. Your field guys got to know what happened that day to get your liens properly preserved, because the burden will be on you to prove it. Okay? Questions about late notice number 1 for sub? Whether the notice has to be made because you're working for, you fall under one of those exceptions, the 4 exceptions, gets made at the time you deliver the notice. So you could do the rough work back when the general owns it as a spec house and not need to send out a notice, but now you're about to put that chandelier in. The house is flipped already to the owner because they've found a buyer who's now doing the finishes and working with the general. So now you need to do the subcontractor notice. If you're a general on a residential project that flips like that, the nicest thing you can do for your subs is give them a heads up that that's the case. And they're going to have to start sending out their 60-day notices, and here's the owner's name and address. Why does the general want to do that? Well, I don't want to lien notices on my property. Well, you do if ever you want to enlist those subs' support to have their lien notices and yours start inundating that owner to compel him to pay. Because unless the 60-day notice gets put in by the sub, that sub has no lien rights. You can't cure it like a prime contractor by paying off everybody beneath you. There is a way to get rid of liens altogether on residential property. It's very rarely used in Wisconsin, but I just want to bring it to your attention because I expect that you'll see more and more people, especially at high-end residential construction, custom, high-end, tricked-out stuff. And that is that the prime contractor or general contractor can furnish a payment and performance bond. And where that bond exists, instead of filing lien notices, you file notices on the bond, and your lien rights are gone completely. If ever you get to a situation on a project that's bonded and you have questions, my number's on here, give me a call. That's a...
How would we know that? That would be how do I know that this thing is, you know, the general...
Very often, the only way a sub would know that it's... If you're the prime, the owner's asked you to get a bond. So if you're the prime, you know there's a bond on there or not. Okay? By statute, if there is a bond and a sub asks you, you must disclose it and provide a copy of the bond. So a sub has need only to ask, is this a bonded project? And ordinarily on a residential project, you wouldn't probably be asking that. On commercial, you would all the time as a matter of course. On residential, if it's a really big house, you might make the inquiry. But if you don't know, very often the first time that you find out is when you file that 60-day notice and the owner comes screaming back at you or their attorney saying, this is a bonded project, don't you dare put a lien on my property, rawr, rawr, rawr. And then you'll know. And then you'll say, please furnish me a copy of the bond, I'd like to file a claim. I'm not getting paid. And what do you want to do about it?
Why do the really high-end homes want the project to be bonded, and is that something that we should think might start happening more and more with the economy being the way it is?
I do think with the economy being more fragile, you might see them wanting it. And the reason is they don't want the potential, after they go through the process of building this multi-million-dollar home, of having even a chance of having it go through foreclosure because somebody 2, 3, 4 tiers down doesn't get paid. You know, in this day and age, you can pick your subcontractors very carefully, and they can pick their subs and suppliers very carefully. But somebody even further down in the food chain might be in a bad place because of the economy and go out of business and leave somebody unpaid that you didn't even know to ask for a lien waiver on. Some material supplier, all of a sudden the HVAC sheet metal contractor's filing a lien on your project and you didn't even know they existed. And then you find out your subbed out a piece of the work to Mickey the Dunce, who went out of business and didn't pay his supplier. And now you're having to clean up the mess.
Is that a pricey thing to do, to have a project bonded? The reason I'm asking is I'm thinking, what a great sales pitch for every general contractor, because we've had very high-end, well-respected generals in the area, and had a file where we paid the general, who in turn paid their mason, and the mason never paid the supplier for the brick.
Right,
And
so
then, in a case like this, if there was this bond in place, problem solved, correct?
problem solved, no lien rights for that
So the
supplier.
general can peddle that as like, come and use our company because we're gonna bond.
Some generals do use a bond as a marketing tool so that you don't have to worry about lien waiver collection and you don't have to worry about liens being filed on the property and you don't have to go learn the rules at a seminar like this. But there's a cost to it, and typically it's a few percentage points of the house cost. Now, on a large construction project, if you're building a multi-million-dollar home, a sophisticated homeowner may say, yeah, that's worth the expense to me. But very often what you have is a homeowner who has a modest contingency budget, and they'd rather spend that on gold foil wallpaper and ultra plush carpeting. They're not going to spend it on a bond. Forget it. Give me lien waivers any day. My title company will protect me. They'll watch for all that stuff.
The owner pays for the bond typically?
The owner, well, it gets built into the general contractor's purchase price. The general treats it as a general conditions cost or as a fee, much like the permits, the building permits for the house. And it gets built into the price of the house. But that is one way you could get rid of lien rights if you wanted. Prime contractor, notice of intention to file claim for lien. We're on notice number 2 already. Woohoo! Everybody find the form. You got it? Who hasn't got it? Now, the best part about notice number 2 is that everybody has the same time requirements for filing number 2. So whether you're a prime or a sub. Now, right now, in your packet, if you primarily work as a prime contractor, I want you to look at the prime contractor notice of intention to file claim for lien. But if you're primarily a subcontractor, you don't contract directly with the owner, you can look at the subcontractor notice of intention to file claim for lien because the information is largely the same and the timing is largely the same. What the lien law says about notice number 2 is it is sent regardless of whether notice number 1 was needed to be sent or not. So if, for whatever reason, you were working directly for the owner and you didn't have to send notice number 1, you still have to send, you must send notice number 2 or you don't have lien rights. So if you happen to be on a commercial project as a subcontractor and didn't have to send notice number 1, you still have to send notice number 2 to properly preserve your lien rights. What this document has to have, the magic pieces, you don't have to use the State Bar form. You can put this on letterhead or throw a document into your computer and just print it out as you need it. It has to briefly describe the nature of the claim. What is it that you did? What improvement did you make to the real property that gets you this lien? What'd you do? You furnished windows. You installed trim. You installed gutters. You were the general contractor. What did you do? Second, how much are you owed? What's the amount of the lien? Now, the amount is not necessarily your contract amount. In this day and age, you can have a written contract with somebody that says, I will be paid on time, or I'm entitled to 1.5% month service and interest charges, and all costs of collection, including reasonable attorney's fees. That is not an oxymoron. There is such a thing as reasonable attorney's fees. Okay? All right? You could put that in your contract. Interest and attorney's fees are not lienable. Why do you think that is? Why do you think that is? What? It didn't improve the real property. I know it's going to crush some lawyers out there that they didn't improve the real property with their work, but that's the truth, okay? Interest doesn't improve the real property. So only the principal amount that you're owed is the amount of the claim for lien, okay? Yeah? And third thing, the land that's improved, the land improvement to which it relates. So you have to have the address where you did your work. Now, if you are sending out a notice of intent, unlike the identification notices when everything is all warm and fuzzy and happy at the front end of the contract, this is a notice you're sending out because now you're worried you're not getting paid. Tactically, this is a notice that should raise red flags for a lender, an owner, a title company, a prime contractor, that you mean business, that if you don't get paid, you're going to file a lien and potentially foreclose on the property. So this is a notice that you want to make sure goes to the proper owner. And so even though you checked when you did notice number 1, I want you to check again when you do notice number 2. By any of those means we talked about. You can get a letter report from a title company. You can go check with a tax assessor. You can do a register of deeds search yourself. You can research it online. But you need to find the current owner of that property, best known address. It must be in writing and served on the owner. Now, do you remember what the definition of served is? How can you send it to the owner these days? Give me some examples.
FedEx, UPS.
Okay, express mail service. How else can you send it?
Court server,
A process server, a court server. What else?
any way that you get a receipt.
Any way you get a receipt. Yep. What else could you do? Certified mail. Hand delivered. Let's talk about hand delivery, okay? Let's say the owner's going to be out on the job site, and they've been kind of squirrely, and they've been, rejecting registered mail. They travel a lot. They're never around. But they're going to be out on the job site. If you're going to deliver by hand delivery, I want you to do something to protect your own interests. I want you to take the 2 copies and bring a 3rd copy. And I want you to have a buddy come with you. And if you don't have a buddy, find the other guy on the site. Hey, Joe, watch me while I hand this to Herman Munster. I'm not kidding. You want a witness, because here's what's going to happen. Herman Munster's going to say, oh, I got so many of those, I don't remember if I got this guy's one or not. I don't remember receiving this notice. Now, if you have a 3rd copy and say, signed here, received such and such a date, Herman Munster, and you keep that copy, boy, do you have really good proof the owner got a copy of that. Is this your signature, Herman Munster? Yes, it is. Yes, sir.
Distinction here. When we were at the identification phase, it was confirmation of delivery.
Uh-huh.
Here it's confirmation of receipt. That's what I'm hearing you say.
It's the same service requirement. The only difference is in this example that we just used, we're talking about personal delivery. So personal delivery is the day you receive it. But it is confirmation of delivery. And that's a very interesting, very fussy area of law that's not controlled by the construction statutes, by Chapter 779. It's actually controlled by some delivery statutes elsewhere in the Wisconsin statutes. It is an area that is not entirely clear in the statutes right now. And so your better practice is to always do the most conservative thing. If you know you have a 60-day window to deliver notice number 1, I want you to take 2 steps back, 2 days back. Don't wait till day 60 to file that notice. If you know you have 60 days and it takes the express mail people 48 hours under the method you're choosing to deliver, don't wait until day 59 to send it by that means. Better to have it in the owner's hands. No question is it delivered on time. No question. Because that's what a smart owner's attorney is going to be doing. They're going to be testing. Did you follow the rules? Did you give me 2 copies? Did you send it the right way? Did you include the right address? Oh, you knew Herman Munster had moved because the general gave you the new address. And you still used the old address for the 2nd notice. Too bad, so sad. That's not what the statute says. If the owner can show that they've been prejudiced because of that, you might not have a lien claim anymore, even after you work to put all those things together. Yes?
Can you send my email if you follow e-commerce laws?
Can you send them an email if you follow e-commerce laws? I have to congratulate you. That's the very first time I've ever gotten that question in this forum. There are new federal rules. They're about 2 years old. And in about 48 of the 50 states, There are state versions of the federal e-commerce laws. And what they say is that certain transactions are binding on a commercial consumer, which a residential owner would typically be, I would think would be, but you must comply with e-commerce regulations. Now, most of what they include, in Wisconsin what they include is that you must send sort of like a test email to the owner, and they must respond back saying, I agree to be bound by email. And where you can show that paper trail or Ethernet trail in your emails, it is possible to bind somebody electronically.
They have to agree to it. There has to be
You have to follow the e-commerce rules.
the overt agreement that they'll use it. You just can't send them a text message saying, hi, how are you, and they come back.
Yeah, you can't just send them a test message and then when you get one back say, aha, gotcha. I sent the notice to you properly.
Okay.
Because the one piece you're missing with e-commerce is written confirmation of receipt. The only place that could come from if you send an email is from the owner, right?
Right. So that they send it back to me, I've done e-commerce for real estate and stuff like that, so these are the set up, they have.
That you could potentially bind them electronically if you wanted to. But you got to follow the e-commerce rules. If somebody really wants to do that, and I'm seeing a really exciting trend in paperless projects, in people using computers as a workhorse, that I really want to see people encourage people to look at that and to do. Because it's very easy electronically to get a hold of an owner. You can't always get a hold of them by phone. But you've got a digital camera out on the site. You can link their computer with yours and say, Herman, can you turn on your computer? I got a question. What do you want here? Do you want the brick to go all the way up? Or do you want the stone to start here? And Herman says, I want the stone to start right at your shoulder. And now you type him a little email, because you've already done the email certification back and forth that says emails are going to be binding. And he shoots you back an email that says, start the stone from the top up. And now your job's not stopped. Your mason didn't stop working one lick. He didn't have to come back tomorrow. He's working on your job right now. That's the power of those tools, digital cameras, project websites. Even for residential construction, it makes sense to invest in that kind of technology. But when you do it, you have to follow the rules just like any other process. If you are interested in e-commerce regulations, make me a little note during the break, give it to me, and I will get you the statutes for Wisconsin's e-commerce rules, and you can read them for yourself. If you have questions, let me know.
The state that you serve, you use e-commerce, does it work for that?
The e-commerce statutes say on their face, you follow this procedure, it's the same as if you had an ink signature on a wet piece of paper delivered by snail mail.
But it's okay here for being for lien.
I'm sorry?
It's okay to use the lien notice too.
There's no case that says you can do that for lien right now, but I don't know why, if the e-commerce statute is followed and you have a confirmation, written confirmation from the owner conveyed by email, that a court wouldn't honor that. I would love to be the one to argue that case because I think that that is very, absolutely legitimate, and it's the direction we're all heading. Even though I still shake my laptop like an Etch-a-Sketch when I want the screen to erase. Notice number 2, conveyed on the date contractor last furnishes labor and materials or within 150 days thereafter. Single hardest concept in all of lien law, right there. It's like a plumber's wrench. You know those great big plumber wrenches? And the teeth don't close all the way because you don't want to crush the pipe? Okay? Notice number 2 is like that kind of wrench. You can never get more space than 150 days. But you could, on the very last day, you walk off the job because you're not getting paid. You stop working on that project that very day. You can file notice number 2. And for 150 days after you walk off the job, you can file notice number 2. Now, why does the statute give you this big blob of time like that? Why would you want that? It's all about tactics. It's all about getting you paid. And what you have to do is think strategically about what's best to get you paid. So, for example, you're not getting paid on a job. You just finished today, but you're hearing harumphing. The general comes up to you and goes, "Oh, I'm really sorry. This owner is driving me crazy. They won't pay for the extras. They won't pay for your extras. I'm so sorry. They verbally authorized it. We started with the work, and then I didn't get her. They wouldn't sign the written change order. Or they canceled my draw. Or all sorts of other things, okay? Or I have a problem with your work, and I'm not going to pay you." All of those circumstances require a different kind of response, don't they? It makes a difference why you're not getting paid, okay? If you're not getting paid because there's a problem with your work, you might want to go further out in that 150 days and use some of that time to clean up the problems with your work. You know, if there's punch lists sitting out there, get it done. Because you want a clean claim for funds in lien foreclosure and not an argument back. You're not really owed $90,000, you're only owed $85,000. And so instead of getting a quick judgment, you're going to go to trial 18 months later to figure out how much you're owed because you still have punch list items out there. It gives you time to negotiate. I don't want to go back to this project ever again. This Herman Munster is a Fruit Loop. I'll give you $3,000 off the top, General. You fix it. You can negotiate in that 150 days. You can contact the owner and the title company and the lender. Oh, we're finding out the owner screwed up. I had a very interesting case up in northern Wisconsin. And the owner was building in a subdivision that had all two-story houses. Very nice, nice residential subdivision, well along in the development. Owner gets a set of plans approved and a loan for a two-story house. And about a third of the way into the construction of the first floor deck, the owner goes, I've always wanted a jacuzzi and air conditioning. I didn't put any money in for air conditioning. And, instead of these little tab shingles, I want dimensionals. I want a bunch of upgrades. I want really juicy, fun stuff in my house. The contractor goes, well, I can help you with that. We'll just rearrange this house, and we're going to take that second story off and use the money to build really nice things on the first floor. So it'll still cost the same. It'll just have much nicer amenities on the first floor. Well, that went along right until the roof went on. And the bank's inspector came out to approve a draw and went, where's the second story? And the owner said, oh, we had a change order. And the contractor said, oh, we had a change. And the lender said, excuse me, I need a new appraisal. And now this poor homeowner and this poor general contractor who didn't, all they were trying to do is build this guy's dream house with the jacuzzi in the back, and the appraiser says, in this subdivision of two-story houses, this one-story house doesn't appraise out. And the whole loan stops. Everything freezes. And the owner can't get more credit. Don't let this happen to you. It makes a difference. So you want to make sure. That's why you see some lenders saying, I want to be told every time there's a change order. You see title companies say, I want you to amend your disbursement control affidavit when there are changes so that we can watch for, oh, now you're adding a crystal chandelier and ultra plush carpeting. That's 2 new subs I have to get lien waivers from. And that changes the scope of the work. All of those things make a difference as you put in those notices. All those things tactically can affect when you do notice number 2. Questions about notice number 2. Same timing if you're a prime or a sub. 2 copies served, using the definitions of service we talked about, on whoever is the owner when you send that notice. And it's tied to your last work. Your last work on the property. Yes, sir?
Well, if you're a builder, then it's when the punch list is done?
When the punch list is done. Here's what the rule is. It's called substantial completion. If the work can be used for the purpose for which it was intended, can you get a building permit and occupy it? You probably hit substantial completion, and the fact that you have a scratch on the inside of the underside of the cabinet to repair on your punch list won't hold up that clock ticking the 150 days. If, however, the work on that punch list adds new value, I'm going to come back in spring and put all of the landscaping in. You probably have until spring to start that 150-day clock ticking. Okay? All right, we're going to take a break. And when we come back, claim for lien. Da, 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 da. Okay, thanks. Certainly fine, Miss Genevieve. You guys remember that story?